Please proceed, counsel.
Good morning, Your Honors. Daniel Rucker here on behalf of plaintiffs Jeffrey and Carol Haksluoto.
Could you please speak into the microphone? Thank you.
I appreciate the court reviewing this case, and I appreciate you hearing argument on this. I would like to reserve 5 minutes for rebuttal, if I may. Plaintiff's position on this case is that the act of alleged malpractice accrued on December 26, 2011. The statute of limitations extended through and included December 26, 2013. Plaintiff sent their notice of intent on that day, and under MCL 600.5856C, there was tolling at the time that NOI was sent to the defendants. The notice period of 182 days then commenced on December 27th and extended through to June 26, 2014, during which time, under 2912B, plaintiffs were not allowed to file a complaint. Thereafter, on June 27, 2014, plaintiffs timely filed their complaint, and tolling continued under 600.5856A. This court asked the parties to deal with two issues primarily. One was whether notice of intent mailed on the final day of the limitation period tolls the limitations period. And the court's second issue is whether, if there was tolling, whether plaintiffs were required to file on day 182 or the day after 182 for their complaint to be timely. Your Honors, the Court of Appeals opinion below, in a lot of respects, was very well written, but there was an error. And the error was that they considered the use of the word expire. They rather than asking what 56C asked, and that is when was the claim barred, they asked when did the claim expire. And they found that the claim expired on December 26, 2013. They should have asked when is the claim barred. The claim could not have been barred on December 26th because all the parties, all the courts have agreed that was the last day of the statute of limitations. And the claim can't be barred on the same day that you're allowed to file. So the first day that the claim was barred was December 27, 2013. And that was also the first day of the notice period, which the Court of Appeals recognized. Therefore, the at the time tolling should have applied. As to the second issue, whether so the Court of Appeals essentially erodes the statute of limitation. The defendant takes a different position. They ask us plaintiffs to invade the notice period. And the court's, the statute requires plaintiffs to wait not less than 182 days after the written notice is sent. So it's not 181.5, it's not 180, it's not less than 182. The court rule counts the final day of a period. It includes it within the period, so day 182 is included within that period in which you may not take action. And then the case law has been pretty consistent. I cited Zweier, and I cited Tyra case, and there's also the Burton versus Reed City Hospital case that makes pretty clear that if you're premature, that's insufficient to toll the statute of limitations, and your claim can then be barred. The statute of limitations continues to run. So I think there are a number of sub-issues that come up. The NOI is timely on the last day of the statute of limitations. You can see that in Tyra, the Furr versus McLeod portion of that case. They said this court held that when they sent their NOI on the very last day of the statute of limitations, it was timely. And then if you look at the DaCosta case, which is a Supreme Court case, the court there said if an NOI is timely, the period of limitations is tolled. And I think that gets you very simply to the answer on the court's first question. The immediate tolling, the at the time, I would point the court to Bush v. Shabahang. It's a 2009 case. And they said in that case, 5856C currently provides that tolling is operative at the time notice is given. So it's operative at the time notice is given. In this case, that would be December 26, 2013. Tolling began. And I'll take any questions if the court has.
So you mailed your notice on December 26th, and tolling, on your theory, takes place at the time you put it in the mailbox. So I don't know what time you put it in the mailbox, but let's say you put it in the mailbox at noon on December 26th. So in your theory, you want a whole day tacked on at the end. Why do you get a whole day? Like, why don't we just give you however many hours you saved on December 26th?
Well, the Court of Appeals believed our position was that you should divide the day up. We don't believe that. We don't believe there's a basis for dividing days up.
Why not? I mean,
into fractions of a day, and that's what the Court of Appeals does. So if you do that which tolls the time for that day, then that day should be treated as a unit. That day was tolled.
yeah, but I need a reason why. So I mean, you could go to the post office. You could get a date stamp. You'd have X many hours. Why does the statute command that you get a whole day?
Well, it's about the way that the court counts days, and they count them by full days. They don't count them by, hours or 15-minute increments or anything like that. So if we went to the point... But
your theory rests on tolling at the time that you filed. So you don't want to lose a whole day because you could have mailed your notice, the moment before the post office closes, I suppose, or whatever time it would still, maybe you could have mailed it at 11:59 p.m., but then you want a whole day back.
Well,
So I'm just wondering why you get a day, but you don't lose a day.
I think it's not that we're asking for a day back, it's that the day was tolled. And I would point to the way it's been treated under 5856A. So if you file a complaint on the last day, your time doesn't continue to run so that your statute is exhausted. I mean, if somebody filed a complaint on the last day in a no-fault action and their time continued to run, you'd say the statute of limitations was exhausted, even though the 5856A says that there should be tolling at the time. So I think if you get into the situation where you're losing the day, you're overlooking the at the time tolling. You're eliminating that immediate tolling provision, and you're not giving it immediate tolling.
Practically speaking, how would it work? If you let's assume you went to the post office on 4th Street in Detroit, which is open till midnight, and you filed or mailed your notice, and let's assume further, which I'm not sure is the case, that they somehow have a way of time-stamping your mail. Maybe they have a way of doing that. I guess I'm not familiar with it. But say they time-stamp it, that you mailed it at 8 o'clock. So now you have 4 hours left. Practically speaking, would you have from 12 a.m. until 4 in the morning to file on the, I mean, how would it?
Where would those 4 hours come from?
Yeah.
How would courts sort that out?
We're almost to an e-filing world, but we're not quite there. So how do we align that with the business hours of the court where you have to do your filing? Or do you get from 8:30 when they open until 12:30? Or how would it, practically speaking, work?
Again, I'm not asking the court to subdivide the day. If you do what is necessary on the last day of the statute of limitations to serve that day, you take it, you put it back in your pocket.
My question is, I know you don't want that to be done, but my question is, could it be done?
Could it be done if you subdivided the day up?
How would it work, practically speaking? You file cases in courts.
Well, it would depend on county to county. If you could only take action.
If we were going to arrive at a rule, can you think of? I mean, maybe you can't. Maybe that's the answer. But
I think the easiest.
Think of a rule.
I think the easiest rule is to stay with the one that we have and count by days. Is to count by days. If you do that act on the day, the last day of the statute of limitations, the easiest rule is that whole day is told. And if we start subdividing by hours, I think it gets very complicated. And I think the courts rejected the hourly position.
And Justice Larson points out that you're asking us to add a day. We could count by days and subtract a day too. Why one over the other?
Well, I don't believe you're adding a day. I believe you've done something on that day, and the statute 5856C says there's tolling at the time. And so I'm not asking to add a day. I'm asking to give that portion of the statute meaning and to toll at the time.
Well, if you filed at noon, you're getting plus 12 hours. if you get the whole next day, right? And if you, or you're losing, you're gonna be minus 12 hours from your statutory filing period if you lose the whole day, right?
If you begin to subdivide the day, then you would look at, are you adding or losing 12 hours? That's correct, but I would not take the position that the court should begin subdividing the days. Just at the time, meaning...
I know where you want us to get. We're trying to figure out the rationale for getting there. So just, I understand that's where you want us to get.
Well,
But you gotta help us figure out why we
okay,
should
I-
travel down the road with you.
I may not be... It comes back to at the time notice is given.
I mean, if we count by days, one way or another, you're either gonna get plus 12 hours or minus 12 hours under her hypothetical. That's the reality of the way time works in the dimensions of the world as I understand them to be. So however we arrive at the rule, that's the reality. So the question is, why your outcome and not the other side? Why should you get plus 12 hours and not minus 12 hours? I mean,
Well-
one answer might be, well, if you subtract 12 hours, I've lost a half a day from my statutory period, and that wouldn't be fair. And maybe that's an answer. We need some rationale, though, to get to your conclusion.
Well, again, I would go back to the way that the 5856A has been interpreted. If you say that you file a complaint on the last day of the statute of limitations in another case, in a case that's not medical malpractice, and yet the statute continues on for the rest of the day and is exhausted, then any case where you file on the last day of the statute of limitations, your claim would still become, your statute of limitations would still become exhausted. If the court took the position that filing on the last day, you lose 12 hours, you lose 8 hours, you lose 5 hours, all these other cases that in the past, and I've cited many such cases where courts have held it's timely to file your complaint on the last day under 5856A, all those cases would be controverted now. So in those cases, the day that you file, all you have to do is file to meet the statute of limitations, and I don't think you should then allow the statute of limitations to become exhausted when you've taken the formal act that the statute calls for. And so that day should be a unit of time that you retain in the limitations period.
Is it as simple as the court rule always speaks in terms of days and nothing less? And you had the ability, at the time you filed, you still had the ability to bring within the 2 years. And so the tolling began at that point. There's no question you were entitled to tolling. So when the tolling expires, you look to the court rule and it talks in terms of days.
Correct, Your Honor.
Well, it's not just the court rule, it's also case law of Michigan too, isn't it?
Pursuant to the case law as well. And
You say presumably it's case law?
pursuant to the
Oh,
case law as
pursuant to
well,
case.
yes, sir. So, I've cited a number of cases where they filed things on the last day, including the tire case that I mentioned. O'Mell and Chuck, I believe they had, I don't know that they filed on the last day, but the court at least recognized in that case that you had 2 years from February 14th to February 14th, 2 years later.
Did you cite Warren versus Slade or Griffin versus Forrest?
Warren versus Slay, Griffin versus Forrest, I don't recognize those right off, Your Honor.
Warren versus Slade is an 1871 case that says our law rejects fractions of a day. And then in 1882, 11 years later, we said that rule in Warren best accords with the common understanding and is at least likely to lead to mistakes in the application of statutory provisions.
I largely just relied on the Court of Appeals position that we don't use fractions of a day, and on the court rule itself that doesn't speak in terms of days, but I think those Supreme Court decisions are as valid now as they were in 1871. We count in terms of days. And I did cite a case, I think it was, I can't recall right off, but the counting was, the way that they count in terms of 2 years under the court rules is for the convenience of the parties, the convenience of the courts, so that it's easier to understand what your time frames are. I think that's very important to litigators and parties who, particularly in a case like this, who have injuries that they're dealing with, and litigators who are trying to investigate the situation. They need to be certain of their time frames and not have to wonder if the statute of limitations is going to be eroded or if they're going to be required to invade the notice period when the cases that have gone before indicate that they do not have to.
But those 19th century cases, at least in my mind, kind of focus the question on whether or not, as Justice Viviano indicated, it's the elapsed part of the day or the unelapsed part of the day that needs to be disregarded. Do you agree with that?
Your Honor, I believe that you need to count by a full day. I don't think you would do like a rounding up or a rounding down. I think if you take the formal act on the day that the formal act is required, the sensible, the reasonable thing to do is either count that
Well, I
day as
agree
told.
with you. We don't think in terms of temporal limits that are less than a day, but I don't know that that answers the question whether we round up or round down. It simply, those 19th century cases simply stand for the proposition that we do round up in some respect. We don't try to focus on, you know, the precise moment or minute of the day in which at which the NOI was filed.
Well, I think if you take the action that's requested of you by the statute on the day that is requested, that is required, then I think the rounding would be down so that you keep that day, because you've done what the statute calls for in the time that the statutes call for you to do it. And so therefore you should round down at anything, because you don't. Am I using
as
the
with
right word?
Justice Viviano, I understand that's your position. I'm still trying to understand why you think we round down. I mean, I can think of some arguments for and against that, but why do you think we round down?
Again, it's because you've taken the act that the statute calls for. 2912 says, you know, you sent the notice of intent, and you've done it timely. You've done it in the time that it calls for, and that is within the 2-year statute of limitations. And therefore, because the claim isn't barred in that time, it's not barred yet. It's not barred until the statute of limitations is completely ended. The claim isn't barred. So 5856C would say that you get tolling at the time. So I'm just going from statute to statute as to the reason why. And am I missing entirely your question?
So you get, oh, I'm sorry, did you want to?
No, go ahead.
You get, let's say we concede that, you know, you file the thing on the last day of the statute of limitations period, you file your notice, tolling begins immediately, but then there's another question. The statute says you get 182 days, so why don't you file on the 182nd day rather than, you want to file on the 183rd day?
The 182 days begins the day after the event. So the day after the event, the mailing, the notice of intent, that 182 days begins on December 27th. And the final day would be June 26th, which is included in that 182 days. And that's counting under 1.1081.
Right, but the final day is June 26th, and you filed on June 27th.
The final day within the 182-day period. And the 182-day period is a period in which you may not take action. So June 26th was within that period in which we may not take action. The first day we could take action then was June 27th. And because we'd reserved one day under the statute of limitations, that was our remaining day.
Okay. You've reserved 5 minutes, Counsel.
Thank you, Your Honor.
Okay. Thank you.
All right. Good morning, Your Honors. Excuse me, getting over a little bit of a cold. Jared Trust, appearing on behalf of the appellees, Mount Clemens. The questions focused by this panel are, in essence, the crux of the Court of Appeals decision regarding that an NOI served on the last day of the statute of limitations does not provide a tolling. Defendants also included within their response to the application, and as Justice Larson had asked, in reference to when does that tolling period begin. Assuming under either option, whether the NOI served on the last day does not toll the statute of limitations, or as Justice Larson was asking, this 182-day time frame, plaintiff's case is, under both situations, time barred. So if we take a step back and actually focus on the most recent question about, let's say that the NOI did toll the statute of limitations. We have an NOI that was served on the last day of the statute of limitations, which under the case law that has interpreted the statute post the amendment we have an indication that you had 0 days remaining on the statute of limitations. It's not disputed that the alleged claim arose on December 26, 2011. It's not disputed that the NOI was served on December 26, 2013. There is not an extra day that's being tacked on by any means. The statute of limitations is 2 years. As set forth within our brief, an exception to the statute of limitations, such as tolling, is to be very strictly reviewed. It's giving plaintiff an opportunity to have additional time that was set forth by the legislator to file an action. Let's analyze this. We have a 2010 Court of Appeals decision, albeit unpublished, and we have 2 additional cases that specifically analyze an NOI served on the last day and if that provides any tolling. Plaintiff's complaint was filed on December 27, 2013. It's untimely. Defendants did not make the decision to advise plaintiff, hey, you know what, wait until the final day of the statute of limitations. Again, 0 days remaining on the statute of limitations, and then take an extra day to make it 183 days. That within itself, that line of reasoning or that line of rationale has not been exposed or supported by any Court of Appeals decision or as set forth by the legislator in the statute itself. This is not a situation where we are dealing with let's divide time in half or let's add additional time, because as this court is struggling, that provides perhaps a lot of discretion, even if you're mailing it from a different time zone. What do we do with that? There's an attorney that's licensed in the state of Illinois, and they're mailing from the central time zone. How do we struggle with giving an hour additional or an hour less in terms of the statute of limitations? We don't actually even have to get there, because MCR 1.108 and the case set forth, the Warren case in the 19th century, indicates that we look at things by a whole day. We're looking at things as a whole day in light of the court rule, in light of the statute, as statute of limitations, assuming the NOI provides a tolling period, does not provide 183 days. It does not provide 181 days. It says that the action may not be filed less than 182 days. In essence, the time remaining on the statute of limitations is tacked on at the very end. So we're looking at that, and we look at the days, not in dispute. Again, 0 days extra, 0 days added. The action was untimely, as it was filed on June 27th. Now, the Court of Appeals set forth something that, honestly, I didn't analyze the case of, and that is the NOI being served on the final day of the statute of limitations. Does that provide a very strictly construed tolling? The Court of Appeals, in analyzing 1.108 and 5805 and 5865C, indicated no, it doesn't, because as 1.108 states, it occurs 1 day after. That unit is 1 day after. It's untimely. And we can get into the dispute of, well, the NOI was mailed on December 26th. Does the notice period begin on December 27th? Because technically it's placed in the mail. If it's not immediate via email or email service or so forth, I don't get it at the earliest until December 27th. We could engage in that, but we don't have to, because upon review of the statute and the court rule and the case law that has interpreted the statute post-amendment, the conclusions are the same. And the reasons why the conclusions are the same is because the tolling is to be strictly construed. An exception to the statute of limitations is to be strictly construed.
Your position is that the plaintiff can't file on the last day?
I'm sorry, I apologize.
Your position is that the plaintiff can't file on the last day of the statute of limitations period?
Correct. That, and in addition, even assuming that that is okay to file on the last day.
Wait. You're moving on. Let's.
Without tolling, is that your question?
Yes, I'm sorry. I apologize, Justice. I didn't mean to interrupt you.
Under this scenario, the plaintiff can't, under these statutes and court rules, the plaintiff can't file their notice on the last day, right?
Correct.
The Court of Appeals used the term deadlock. I'm not sure if that's the right term or not. But your theory is that even though the statute says that it's a 2-year statute of limitations, really it's a 1 year and 364-day statute of limitations.
No, I agree with the first part in terms of that an NOI served on the last day does not provide tolling. The second part, respectfully disagree with that. It's not going to be a 1 year, 364-day time period. It's in essence going to be a 2-year time period to file an action. But in light of the addition, or in light of the exception to allow tolling if a notice of intent is served, that extends the statute of limitations. So for instance, if we take a step back and see that plaintiff filed a notice of intent with 30 days from prior to December 26th, let's say in rough math, November 27th, for lack of better terms, without calculating the dates. They would have 30 days plus the 182 days, because that serves to buttress and to provide and to preserve time. But an NOI that's served on the last day of the statute of limitations does not provide tolling, and it does not provide any exception allotted by the legislator to allow more time to file a medical malpractice action.
Except that allows you to recover the unelapsed part of the day on which the NOI was filed. That's what that last day, what you call the 183rd day, I'm not sure I agree with that characterization, but be that as it may, I mean, that's the purpose of that 183rd day, is to allow a recovery of the partial day on which the NOIA was filed, and at the same time to take cognizance of the fact that we don't look at partial days in order to calculate the number of days, but we might have to look at a partial day to recognize that the plaintiff has been deprived of that opportunity. In other words, we have to either round up or round down, and we're rounding up because we think that that's a better way of reflecting the fact that the notice of intent shouldn't be, as we said in Omalenchuk, a matter of deceiving the unwary, but rather it ought to be something that recognizes that in case after case after case, we've said that a filing was proper when the NOI was filed within 182 days before the statute of limitations.
Well, that's actually the crux of the point, and the point being is that the statute of limitations, again, uncontroverted, is 2 years. The notice of intent period, and then in a provision to allow additional time to file an action, the dates chosen to mail this NOI, again, is plaintiff's burden and plaintiff's issue to choose. There was nothing that prohibited plaintiff to serve or to mail the NOI a day or two before the expiration of the statute.
So who cares? What's the point? I mean,
Well,
it was filed when it was filed. The question is, when it was filed, was it legitimate? Did it toll the statute of limitations and allow for what happened on the last day?
Particularly, if I can supplement, particularly in light of the statutory language, it says it's told at the time. At the time, the limitation period had not expired.
And the response to that is setting aside the Court of Appeals decision and focusing on the second issue that the court asked the parties to address. The statute of limitations is told for a period not longer than the days remaining on the statute. We have an NOI that was served on the very last day, 0 days remaining on the statute of limitations.
There was time remaining.
Assuming the NOI is timely, assuming that we have 0 days remaining on the statute of limitations, okay, 182 days elapses, 182 days. This action was filed on 183 days. There is not an addition of 1 day. We're dealing in days and dates set forth within the court rule saying that the action starts, that if the NOI is served on the very last day, you're afforded 0 days in addition to 182 days.
Doesn't the NOI become precisely what we said in Omalenchuk it should not become? That is a trap for the unwary when the NOI is filed on an appropriate date, and according to DaCosta versus Gossage, if an NOI is timely, the period of limitations is told. In Tyra versus Oregon Procurement, we said an NOI filed on the final day of the limitations period is timely. Doesn't it become precisely what we warned against in Omalenchuk, a trap for the unwary, if in fact it doesn't toll the statute of limitations and allow for the complaint to be filed within the scope of that statute of limitations?
Respectfully, no. because it's still allowing plaintiff an additional 182 days plus the time that they have reserved on the underlying statute of limitations. So this isn't by any means a trap. This isn't by any means saying you can't go forward with your action. And again, this is assuming the NOI provides tolling. This isn't an issue where the legislator is saying, or even I'm saying, that this is a trap for the unwary. This is a portion of the statute, reviewing the statute in light of the court rule and the analysis of the Court of Appeals decisions following that, that indicates that you have not less than 182 days plus the days remaining on the statute.
But you're depriving the plaintiff of the 5 or 6 or 7 hours to which he or she should have been entitled, but for the fact that they filed the NOI before the absolute last moment at which they could have filed it. And it's because of the rule that we have against fractional days that those 5 or 6 or 7 hours become transformed into a full day. And that's what's happening at the end of this process, is it not?
It's not what's necessarily happening at the end of this process, because the issue is that if we do go down the route of subdividing days, such as this, the justices were questioning Mr. Rucker on, we are going down a route that is not set forth by the legislator, not set forth by the court rules. So the days, the units, the issue of mailing from different time zones, we avoid all of that. And the reason why we avoid all of that is because the court rule and the statute indicates that we assess this by days.
Let me share with you how, in my mind's eye, I see that we are not adding any time and why I am tending to disagree with your position. All right, I'm coming to this argument tending to disagree with you, and I'm going to share with you why. I've got an abacus. It's got 2 years' worth of beads. And I look at the statute, and here's the injury. At the end of the day, after we move the first bead. And we do that every day. And now we're down to the last day. That bead is still on the right side. I can't move it. Before the day expires, they file the NOI. And now I've got the abacus of NOI. It's 182 days. When do we move the first bead? At the end of the next day. And we go through until 182 days are gone. We still have, back at the statute of limitation, 1 bead remaining. And so to me, I don't see that we're adding any time at all. And so in light of this description of why I disagree with you, can you share with me your thoughts as to why that is inaccurate?
Absolutely. We'll take the DaCosta opinion and the notice of intent, again, assuming that it did provide tolling, the mailing, the date on the notice of intent provides the time to calculate additional dates remaining in the statute of limitations and then thus to apply tolling. So we have a statute that states, specifically, that states that the statute of limitations is told for a period no longer than the 182 days plus the days remaining on the statute of limitations. We had 0 days remaining on the statute of limitations.
That's where we disagree. I still have a bead to the right that I haven't moved over.
Well, of course, but the problem is that that bead itself, under the Court of Appeals decisions and under the Court Rule 1.108 and the statute itself, should have been moved over.
At what point do we move it over? Why should it have been moved over? If it should have been moved over, then it was not told at the time. You're saying that there was no time left.
Well, there's no time left on the statute of limitations, and that's what the statute says. The tolling proviso.
If the NOI wasn't required, instead of filing the NOI and they actually filed a suit, would it have been timely?
Well, under the Court of Appeals rationale for the first issue, finding that the tolling didn't apply, it wouldn't. But in this instance, if there was no tolling and there wasn't a notice of intent filed, the action would have been timely.
Okay.
Absolutely.
So at the time, if it's told at the time, I'm having a hard time finding
well, and that's
what's left afterwards.
Understandable. That's why the exception to the statute of limitations, the tolling statute itself, states the statute of limitations is tolled for a period of 182 days only, plus the days remaining on the statute of limitations. If this action, take out Christmas, take out the fact that it was a holiday. If this action, if the NOI was served on December 25th, you would have 1 day remaining on the statute of limitations. So thus you would have 1 day plus 183 days, and the action, if it were filed on June 27th, would have been timely. We would not be here. But the fact is that plaintiff, in reviewing the court rule, and in light of the exception to the statute of limitations, is indicating that under that rationale, they would like the extra day. That's not what the decisions have held. That's not what the court rule states. That's not what the statute states. So I'm not saying that we're depriving the plaintiff of any right to file an action. They had a right to file this action. In this instance, it is an untimely action. So there's no, I'm not standing here saying that if the dates were different or if the NOI was mailed sooner, that they wouldn't have that time frame, but they would have the same calculation. 5 days, let's assume they saved 5 days on the statute.
Essentially what you're saying to me is that I should move the bead over at the beginning of the day.
On the day of is what I'm saying.
And so going back to Justice Viviano's question, what's the rationale for that?
Well, that's, the DaCosta opinion indicates that the date that the NOI is to toll the statute of limitations is the date that the NOI is mailed. So that's the Court of Appeals decision evaluating that, and which appellant also cites as well, but kind of runs contradictory to their argument. So that's what I'm utilizing in terms of saying that you need to move that abacus bead in light of the Court of Appeals analysis of the tolling provision and 1.108.
Going back to an even earlier case than the two I cited when opposing counsel was here, an 1844 case, Dousman versus O'Malley, we said in that case that when a defendant is entitled to a certain number of days of notice, the defendant must get that many whole days, disregarding the fraction of a day in which the notice was initially provided. How many whole days of notice were you provided in this instance? Were there 182 whole days of notice?
Assuming the NOI was timely and told the statute of limitations, we would have been given 182 days. You do not need to.
108. My question was 182 whole days of notice. Is that what elapsed here between the time of the filing and the time that the complaint was put forward?
Well, in order to, and I see where this court's going, in order to answer that as a yes or no.
We're going where at least I'm trying to go where we're going 173 years ago.
Right. The 182 subdividing to 181.5 or rounding up or rounding down or having 182.5 and rounding down isn't necessary in this, though. That's the issue, because it's not necessary because 1.108 deals in days. So admittedly, if the statute of limitations told the general 2-year medical malpractice window, it would be 182 days. If we start subdividing, I'm required to keep the envelope. Plaintiff is required to present the envelope. Plaintiff is required to present the timestamp. I'm required to present the timestamp. We don't have to go there.
Well, you're rounding too. You're just rounding in a different direction than opposing counsel would like to round. I guess that gets back to the point I thought I had made correctly, which is that we are all in agreement that we're rounding. The only question is which direction that rounding goes in.
But understanding that we actually don't have to round in this situation, because the statute just says the NOI is told for 182 days plus the days remaining on the statute of limitations. We have 0 days remaining on the statute of limitations. That's the...
Sort of begs the question. I mean, I think we're talking in circles now.
Okay, I'm sorry. I don't mean to not answer the court's question. I'm just...
Let me talk in circles for one more minute. On the abacus bead, I'm trying to understand your theory of this case. And if it's, I don't understand how something could be told, the limitations period could be told and also expire at the same time. So if you want the bead to be moved when it's told, that means there's nothing left. So what's the point of tolling? Not a very effective tolling if all the sands of time run out at the moment you toll.
Of course. Well, I'm sorry. I should have clarified myself. Assuming that the NOI did provide tolling, we would move the bead. Under the Court of Appeals, appropriately and well-reasoned decision regarding...
I'm addressing your assumption. assuming that it tolled, you say the sands of time run out immediately. So that's like saying it tolled and it didn't toll at exactly the same moment, right? The moment you
No.
tolled is the moment you ran out of time and the beat moved over and game over, goodbye.
No, arguably, under
I mean,
the
this case was over right when they filed the notice on the last day, right? Under your theory.
assuming the NOI,
They could never timely file after that, right?
no, actually, assuming if the NOI was timely and did provide tolling, you provide 182 days. You serve on June 26th.
And you can assure me that we wouldn't be facing your lawsuit for them filing.
Too early.
Yeah, too early, which is, what we dealt with last month. I mean, we deal with these one-day cases, it seems like, all the time, no?
Understandably, no.
But so no
You
defense
wouldn't-
lawyer in Michigan would have brought the case and made that claim.
I would not be before this honorable court if the action,
Well, maybe
if
not
assuming,
you, but they would have got someone else. Across the street.
my client's sitting in the courtroom, so hopefully not, but anyway. No, assuming.
Your client's my local hospital, by the way.
Well, wonderful.
Attorney General.
I've been before your
Stay healthy.
Your Honor and the circuit court level as well. If, assuming the NOI does provide tolling, and assuming the 182-day window, an action filed on June 26, 2016 would have been timely, and we would not, I would not be raising a C7 challenge at this time.
Okay.
The
Any
panel has
further-
any additional questions? Thank you very much.
Thank
for
you,
your
counsel.
time.
Counsel, you have 5 minutes.
There are just a couple of things I would like to respond to. One is, I'd point out that I cited the collateral liquidation case in Michigan, 296 Mich. 702 from 1941. It says the court tries to avoid, it's the court's policy to avoid a forfeiture. And so when we're talking about rounding, I think, Your Honor, when you were talking about rounding, I was thinking rounding down to 1 day less than 2 years. But you were talking about rounding up to a full day that you have left, so I think I would go with your rounding up.
I thought you
I
might.
think we were speaking about different rounding. The issue with the receipt of the mailing of the NOI is addressed in 2912B, paragraph 2, where it talks about proof of mailing constitutes prima facie evidence of service, of compliance with this section. So I think that's an issue that the court doesn't need to spend a lot of time on. If we have to prove mailing in the trial court, we're capable of doing that. I don't think that these are two periods that can be tacked one to the other. One period, statute of limitations, allows you to take action. The other period prevents you from taking action. The 182-day notice period prevents you from taking action. They are not one elongated time period. And I would point out, too, because we're talking about the full day issue, or I'm sorry, the 2912B in Burton v. Reed Hospital, that this court has said that 2912B unequivocally provides that a person shall not commence an action until the expiration of the statutory notice period. So when you get to the day 182, you may not commence on day 182. And I think that's important in combination with what Tyra said, and that is if you file, you mail your NOI on the last day of the statute of limitations, it is timely. For the court to say that that's timely and then to also now hold that you're barred would be inconsistent. Why would you have a timely served NOI and have no time to do anything? Why would courts like Driver v. Nani say if you file it within the statute of limitations, if this court found that you're nonetheless barred, why would they have made these earlier rulings saying that it's timely within the limitations period? So I would say if the court does find, for whatever reason, that it's improper to file it on the last day, or that for whatever reason we are now required to invade the notice period and file our complaint, that the court would make this a prospective ruling that would affect prospective cases and not cases where we believe we were counting correctly based on cases like Tyra and precursors to that and the statute that says it's told at the time.
So we would have one rule for your case and one rule for the next guy's case?
Not in just anybody up to this time who had, as I believe, done it properly. If they served the NOI timely or mailed the NOI timely on at least by the last day of the statute of limitations, and then they had waited the entire 182-day notice period, and then used their bead or their chip the day after, anyone who's done that, I contend, my primary argument is that they were timely. And then 5856A tolls the statute from there on out. But if this court finds that these prior cases were wrongly decided for whatever reason, or at the time is not appropriate for the last day of the statute of limitations, that you don't get tolling at the time, I'd ask that the effect of the court's decision be prospective only.
And what exactly would be your precedent for that kind of approach to giving meaning to the law?
I'd look at cases like Bryant versus Oak Point, where if this isn't negligence of counsel, but understandable confusion about the way the statutes interact, that there's a good basis for applying equity, at least to those who are find themselves in this circumstances, not from being negligent. And in this case, counsel, I can say, was not negligent. There were pressing issues with experts that took them right up to the last day. And that can happen because you're waiting on documents. That can happen because you're waiting on an expert. But you need the 2 years. And you're not allowed to use 182 days. So thank you, Your Honors.
Thank you, counsel. Case is submitted.